The United States Supreme Court has issued a massive emergency ruling, completely overriding a lower court to deliver a historic constitutional victory for state sovereignty. In a high-stakes showdown over congressional redistricting and election laws, the Supreme Court officially granted an emergency application for a stay, instantly wiping out a lower court injunction and restoring the exact congressional map that Republicans wanted for the upcoming election cycle. But the real story did not end with the emergency stay. The state has officially filed a petition for a writ of cert before judgment in the Supreme Court, asking for the Supreme Court to bypass the 11th Circuit's ruling in consideration of this case and in fact decide this case on their own. This means that the state is not waiting around for years in additional litigation in the lower courts. Instead, they are asking for the Supreme Court to permanently settle this legal question right here and now. And when you combine this writ of cert with the Supreme Court's recent emergency stay in this case, it becomes increasingly clear that the court may be preparing to fundamentally reshape how federal courts handle election law challenges moving forward. So in this video, we're breaking down what the Supreme Court did in that emergency ruling, the new cert petition for the writ of cert before judgment that was issued, and the questions now being presented to the High Court and why this could become one of the most important election law cases in America. Now, before we jump into what is going on with this case in front of the Supreme Court, if you like this type of content and you want to ensure that you get updates on this going forward, make sure to subscribe to the channel and turn on all notifications to never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. So myself as an attorney, I am always thinking about, what would happen if I ever have to get in a self-defense situation. I'm a concealed carry holder. I carry wherever I go. But I'm always considering, what happens after the fact. And one of the companies that I've partnered with is Attorneys on Retainer. And as an attorney, they are the law firm and the attorneys that I would trust with my freedom if I ever had to deploy my firearm in self-defense. So if you're interested, if you want to check them out, they are always expanding upon their benefits to try to give members as much as possible. If you're interested, if you want to look at their coverage, check them out using the links down below. And right now, if you decide to sign up and you use my code ARMSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family sign-up fee. Now, to understand why this issue has gone directly back to the Supreme Court, we first need to understand what happened in the lower courts. Now, this entire dispute centers around congressional redistricting and the Supreme Court's recent decision in a case called Louisiana versus Calais. In Calais, the Supreme Court substantially clarified how federal courts are supposed to analyze vote dilution claims under Section 2 of the Voting Rights Act. The court emphasized that lower courts must properly separate race from politics, respect legitimate state districting goals, and avoid treating every political disagreement as evidence of racial discrimination. Now, following that ruling in the Calais case, the Supreme Court sent several redistricting disputes back down to the lower courts for reconsideration under the updated framework and legal analysis. And one of those cases involved an Alabama law. But according to Alabama, instead of following that Supreme Court instruction, the lower courts largely repeated the same legal errors that the Supreme Court had already struck down in that recent ruling. The district court once again blocked Alabama's 2023 congressional map and forced the state towards a court-drawn alternative special master map. Alabama immediately returned back to the Supreme Court seeking an emergency relief and a stay of that lower court ruling. And the Supreme Court responded by granting Alabama that request for an emergency stay. When the Supreme Court granted Alabama's request for that stay, the majority did much more than just simply saying that the lower court got this wrong and, pausing their order. The Supreme Court specifically concluded that Alabama had demonstrated a strong likelihood of success on the merits. Now, that language is very important because when the Supreme Court grants emergency relief while simultaneously indicating that a party is likely to prevail, it often provides a roadmap for how the court views the underlying merits of the case. The court concluded that the lower court failed to properly apply that Calais framework. The Supreme Court found that the lower court failed to presume that Alabama's legislator acted in good faith. The court also concluded that the district court improperly relied on alternative maps that did not satisfy Alabama's legitimate non-racial districting objectives. Those findings became the foundation for what happened in that order. After Alabama got that emergency request, there was also a clear procedural sign that they would seek permanently to win this case and seek Supreme Court review of the merits of this issue. And that has now actually happened. Alabama has officially filed for a petition for a writ of cert before judgment. Now, I want to note that is a highly unusual procedural move. Normally, a case would proceed through the Court of Appeals, the lower court, before reaching the Supreme Court. But Alabama is asking for the Supreme Court to skip the 11th Circuit full review of this case entirely and, in fact, resolve the dispute on their own. The state's argument is very straightforward in this case. According to them in the petition, the lower court continued applying legal standards that conflict with the Calais framework and failed to properly account for Alabama's legitimate districting goals. Alabama argues that further proceedings at the lower court are unnecessary because the Supreme Court has already provided the controlling framework, and they also say effectively that the lower court has shown on multiple occasions that they will not follow Supreme Court precedent. The state is effectively telling the Supreme Court that you already answered these questions in Calais. The lower court ignored that guidance on multiple occasions, and now the Supreme Court should simply step in and correct the error directly with full review on their own. Now, what makes this case so significant is that it's not really just about Alabama alone. This dispute has become a vehicle for answering much larger questions. How much deference do states actually receive when drawing congressional districts? How should courts distinguish race from politics? And when can federal courts override state redistricting decisions in those types of maps that they draw? And also, can states pursue traditional districting goals without automatically being accused of discrimination? Those are questions that affect election laws and these types of disputes nationwide. And that is exactly why Alabama is seeking immediate Supreme Court review, and they want the Supreme Court to decide this on their own right here and now. Now, the next major question is whether the Supreme Court will actually agree to hear this case. I think it's highly likely that they will, because that stays in place essentially until this case is resolved. And Alabama is just deciding to go directly to the Supreme Court to resolve this on the merits. If the court grants cert before judgment, it would bypass the 11th Circuit and move directly to full Supreme Court merits review. That would dramatically accelerate the timeline and give the language already used by the Supreme Court during that emergency state proceedings even more authority, and would likely, also lean towards Alabama winning this case. And Alabama already clearly believes that they have a strong chance of prevailing on this issue based on what the Supreme Court already did on that emergency stay. If review is granted, the Supreme Court could use this case to further cement that Calais framework and provide additional guidance on the relationship between the Voting Rights Act, state sovereignty, and constitutional limits on race-based districting. Now, right now, the Supreme Court has in some ways responded. They told the opposition here to this law that they need to file a response by mid-September. They did grant them a little bit of an extension, but the response will be filed. The opposition will be arguing that the Supreme Court probably should not review this right here and now. Instead, the 11th Circuit should get another shot at reviewing this case. But of course, Alabama's main position is that the 11th Circuit and the lower courts have had multiple chances at reviewing this. Every time that they have reviewed it, they try to go against Supreme Court precedent. And so that, again, is their main position, is why are we going to waste all this time at the lower court level when the Supreme Court could just apply the framework already on their own and get this correct? So the legal battle that began with Alabama's emergency stay victory has now entered an entirely new phase. The question now is whether the Supreme Court will be willing to take this case immediately and issue a full merits ruling on their own. So as this develops and as we get more information, as we get more news from the Supreme Court on this issue, I will let you guys know, but let me know down in the comment section, do you think the Supreme Court is going to step in immediately on their own and issue their own ruling? And do you agree with the Supreme Court's initial granting of the stay, allowing Alabama to put in place their own redistricting, laws and their own, map that they had originally wanted? Or do you think the Supreme Court got this wrong? Let me know down below in the comment section your thoughts. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.